Hey, everybody. So today I'm outside of the Supreme Court building, as you can see. Very hot here. Um, oh, there goes a car. Wow. Anyway, I thought I would talk a little bit about the federal court system. And so we're not going to go to all the courts. We're not going to go into the military courts. My hair's all messed up. Or the patent courts or anything like that. We're going to talk about the three main courts. But before we get into that structure, let's make sure that we know that judges are appointed by the president uh, for life. Now, they have to be approved by the Senate. They have to be with the consent of the Senate, and they can be impeached and removed from office. And when the president usually is appointing a judge, there's something called senatorial courtesy that comes into effect, which is sort of an informal veto power that a member of the Senate has over a presidential appointment from their home state. So if the president wanted to nominate me for a judgeship, he'd go to probably the senior member of the Texas delegation, John Cornyn, and say, "I'd like to appoint Brian as a judge." And John Cornyn would probably say, "No, Brian's a jerk. He's terrible. He's lazy," which everything of that is true. And then I wouldn't get the appointment. Now, I would never know that John Cornyn said that because that would just make, you know, him another political enemy. The White House would probably say, "Hey, it was very competitive. We wish we could have got you in here maybe next time." But then we'll move on. So judges can, like I said, they can be impeached and then tried in the Senate and removed from office. That can't happen, and it has happened, much like the president. So let's start at the bottom of the federal court system, and that is the federal district courts. These are the principal trial courts of the federal system. There are 94 district courts, anywhere between 3 and 27 judges assigned to them. Sorry, 1 and 27 judges. The number of judges depends on how much caseload that may be. If you're a federal court out in, say, Wyoming, you might be the only judge, but if you're in New York City, you might have 27 judges because you have so many cases. And regardless of the number of judges, each judge hears one case. It's not 27 judges all hearing the same case. The federal district court is the principal trial court. In other words, if you're going to have a jury trial as a citizen in the federal system, it's going to be here. And if you're in front of a federal district court on trial for a crime, you're probably in trouble. They have a 96% conviction rate, so not a good place to be. Now, their jurisdiction is they have original jurisdiction in cases involving the United States, crimes against the United States, and in the criminal field, and in civil cases of diversity of citizenship in states versus other states. And they have exclusive jurisdiction over bankruptcy cases. They do not have appellate jurisdiction. They do not hear appeals because they're the lowest court in the federal system. So we're going to go up the next level, and that's going to be the Court of Appeals. There are 13 of these. Your book says there's 12 plus a special one, and I did the math on that. It's 13. And they have anywhere between 3 to 15 judges, and the judges hear appeals in panels of 3, so you need to convince 2 of them. Remember, when you're appealing a case, you're not bringing in new evidence, you're not bringing in new witnesses. You're just saying, did the judge follow the correct? Did he follow the law? He or she follow the law correctly in your case? Now, they have appellate jurisdiction only. They hear appeals from the federal district court, and they can hear appeals from independent regulatory agencies like the FCC or the FAA. So, for example, if you're on the radio and you drop a bad word on the radio or on TV, and the FCC fines you, you can appeal it at this level. And then at the top is the U.S. Supreme Court, and it's composed of 9 justices. They don't like to be called judges. There's the Chief Justice, that's John Roberts, and then there's 8 associate justices. Now that number is not fixed. It's changed over time, depending on what Congress has done. It's been as low as 5, but it's been 9 for some time. FDR tried to pack it with a bunch of judges in an effort to get them to start approving his New Deal programs and not turning them or claiming they're unconstitutional. The Chief Justice doesn't really have any more power than the other justices, except that has some additional duties, like assigning who's going to write the opinions of the court. Now, the Supreme Court's jurisdiction is that they have original jurisdiction, which is rarely used in cases in state versus state or cases involving foreign minister. That rarely happens. Their appellate jurisdiction is where they hear most of their cases, almost all of their cases. They hear appeals from the Court of Appeals on the federal level and then from state Supreme Courts. Now, if you want them to hear your case, you have to ask for a writ of certiorari. Now, a writ is a court order. And a writ of certiorari is that they say, send up the records. And so you ask for a writ of certiorari by submitting a brief saying, this is why you should hear our case. And the Supreme Court's going to be looking at whether or not there's a significant federal question involved. And if there's not, they're not going to hear the case. They turn down most appeals. They're always trying to find what is the federal question involved and why should they hear it. So the court as an institution tends to be fairly conservative anyway on what cases they will hear. Now, how do they decide which ones they're going to hear? Well, they look over all these briefs for these writs of certiorari, and then they have something called the rule of four. If 4 justices decide they'd like to hear the case, then they'll hear the case. So that means that when you're watching TV or you're reading the news and you hear the Supreme Court's going to hear this case, it doesn't mean they're going to overrule it, because it only takes 4 justices to hear the case. So the Supreme Court meets in October until May, and then when they issue their rulings, they issue opinions. That's what they call them. They go, these are our opinions of what we think is constitutional, what's not constitutional, or what was right or wrong in this case. And there are different types of opinions. There's a majority opinion, which is written by the majority of the justices. There are concurring opinions in which justices will write one saying, I agree with the majority, but for different reasons. And then there are dissenting opinions. Those will say, I think the majority is wrong, and this is why. And sometimes on the really big cases, Roe v. Wade or something, they'll almost all write an opinion because they want their words down there. And sometimes, it's the dissenting opinions that are the most important. If you go back and look at the Supreme Court case of Plessy versus Ferguson, which decided by a case of 8-1 with Justice John Marshall Harlan dissenting. He was known as the Great Dissenter. His dissent in that case has become somewhat legendary. Now, a lot of people don't understand the Supreme Court, and a lot of times when you see on the news, they'll have reporters and they'll interview a lawyer to talk about what the Supreme Court decision is. You have to be very careful about that. There's not that many constitutional scholars, people who don't go into constitutional law. Probably Ted Cruz is one of these people who knows the Constitution and certainly has an opinion on how it should be read. Barack Obama is another one, and there are others out there that you can find. But often the legislature doesn't like the Supreme Court because it seems like you can have one person on a 5-4 decision strike down the will of the majority of Congress because of the power of judicial review, which we've talked about before, came out of the case of Marbury versus Madison. So it's really hard for people to understand what the Supreme Court does, and sometimes they are misinterpreted. So when you hear about a decision, sometimes it's good to read it before you decide anything else. Anyway, that's a short discussion of the federal court system. Our next lecture will be starting to talk about the doctrine of selective incorporation and how we start applying the Bill of Rights to the states. So I will probably film that one tomorrow, and because I got to get out of here at Washington, D.C. I mean, right now things are closed. As you can see, there's nobody, and I've got to hail a cab, taxi, and so it's a taxi. So I have to run. So hope you're all doing well, and I will see you later.